This is case number 21-162-798. This is Metro Med Pain Management versus City of Detroit. Looks like the matter is before the court, scheduled for a general hearing. All right, your appearance for Metro Med, please.
Yes, excuse me. Gina Smith Gallant here on behalf of the City of Detroit, Your Honor. I just spoke with Mr. DeCruz on a text. I don't know if he's coming on, but he did respond. P number 41387, I forgot.
All right, thank you, counsel. So I'm seeing all kind of notes on this. Has this case been resolved?
We are about $800 apart. No, is the short answer, but we're working on it.
All right. So you said you sent a text to Mr. DeCruz, or you spoke with him this morning?
I sent an email. I did send an email and he did respond. That's why I know how far apart we are. He didn't say he was coming on, or I don't know if somebody else is on for him, but he did respond, and I told him we were in court. So,
all right. Anybody here from Metro Med? I'm sorry. All right. So you want me to stand down on this and wait a few more minutes? Come back to it. You think that makes sense?
yes, we can pass, Your Honor.
All right. All right. So I'll pass on it momentarily. I'll come back to it, Madam Counsel. I'll recall the matter. Thank you. All right, the court now calls case number 21-171-3. This is Z-Ride Home, LLC versus City of Detroit. The matter is before the court settlement for a hearing on today's date. Looks like a status conference for the plaintiff, Z-Ride. Your appearance at this time, please.
Morning, Your Honor. John Betts, P24468 on behalf of the plaintiff Z-Ride Home.
Thank you, Mr. To you, sir. For the City of Detroit, your appearance at this time, sir.
Good morning, Your Honor. Ben Patterson on behalf of the City of Detroit, P number 85118.
All right, thank you, Mr. Patterson, and good morning to you as well, sir. I do see that the city has filed this answer together with affirmative defenses and request for compulsory rejoinder, etc. All right, so is it my correct assessment that you need some time for discovery regarding this case? Have there been any discussions regarding moving forward? Go ahead, Mr. Betts, if you will.
Yes, Your Honor. I think a period of 60 days or perhaps 90 days of discovery would be sufficient. If you'd like to bring us back for another pretrial conference, that would probably be productive.
Thank you, counsel. Mr. Patterson, anything?
That's fine, Your Honor.
All right, very well. So I will go ahead and set the matter over. I'm going to set it just beyond 60 days out. So that's going to put us in May. And I'm looking at May 18, 5/18/2022. That's going to be at 9:30 a.m. You're going to get a notice from me with that date and time. I'm going to open discovery formally and allow discovery to continue through that date. That is the date of May 18, 2022. The court is also going to allow for the parties to file motions in the interim if they wish to do so, and set such motions on for hearing on 5/18/22. The court is also shortening the time that would normally be required to file dispositive motions. So what I'm going to allow is that the filing of any motion, dispositive or non-dispositive, is set for hearing on the 18th of May. On the 18th of May, so long as the other party has at least 10 days to respond to the motion. you could file your motion, set it for hearing on the on the 18th of May, May 18, 2022, at 9:30 a.m. As long as the other party has at least 10 days to respond to your motion, I will hear it on the 18th. All right, you'll get an order from me, that same information contained therein. And I wish you well unless there are other issues at this time.
Thank you, Your Honor.
Thank you.
Mr. Betts, all right, good day to the two of you.
Good day.
The court now calls case number. All right, on the 10 o'clock call, this is case number 18-178511. This is Credit Acceptance Corporation versus Gerald Williams. The matter is before the court on the plaintiff's strike the defendant's motion to set aside the default in this matter. The record should reflect that the court did enter judgment by default in this matter. That default was entered on here. Judgment was entered on the 2nd of April 2019 by the Honorable Commissioner Brew. And subsequent to that time, the court does note that there have been various notices regarding garnishments, and then the court received. There's also been objections to various writs of garnishment, and then the court received the motion to set aside default. It seems that that motion was possible recently. Your appearance for the plaintiff credit acceptance, please.
Judge, may it please court, my name is Attorney Richard Bruce, and I'm the attorney of record. My bar number 3522A. I am the petitioner to set aside defendant's installment payment order, which is dated December 4, 2019.
All right. Thank you, counsel. It looks like the notation on one thing says some motion to set aside. Now I see it's regarding the installment payment. Thank you, sir, for that update. All right. Do I have Ms. Soma, Daryl Williams? Daryl Williams, if you're on the Zoom, please say something at this time. Any counsel representing Mr. Williams? All right. I do see that there was an order for installment payments that was entered in this matter at a previous time. And it looks like the installment required a $300 monthly payment commencing on the 5th of January of 2020. Why should that be set aside, counsel?
Judge, may it please the court, two things. My motion today, I'm proceeding under MCR 2.119 in the sense that I do not have a written objection by defendant, and I do not have defendant present despite notice of the court directed to Mr. Williams about the pendency of this case and giving Zoom instructions to be here by Zoom hearing. That being said, my motion speaks for itself in that at the time I filed this motion on the on or about December 21, 2021, that defendant was $7,200 in arrears of the December 4th, 2019 installment payment order, which is referred to in this record. Therefore, because defendant is in arrears, defendant is not present, I would ask that you grant the motion to set aside installment payments.
All right, thank you, Council. Council, there's one question, and that is, has the defendant done anything to make good on the arrearage since the time of the filing of the motion?
Thank you, Judge. That's a fair question. And as I review my electronic record, I see that since I have filed this motion in December of last year, there has been no payment. Therefore, I will stand on written pleadings filing my motion.
Thank you, Council. The court will grant the petition. I'll ask one more time on the case of credit acceptance versus Darrell Williams. If there's anyone here for Mr. Williams, please say something at this time. Right, it looks like Mr. Williams has in fact not appeared regarding this matter. The court did send out a notice. That notice was dated the 5th of January 2022, directing defendant to appear at this hearing on 3/14/2022 at 10:00 a.m. The court has reviewed that notice. It has gone to the address that was established as defendant's address on Shaner Street in the city of Detroit, apartment number 5. Moreover, the Zoom number is correct. The defendant has elected to not appear at this hearing. The court, therefore, and for the reasons set, will set aside the installment order. And I'm signing an order consistent therewith at this time.
Thank you, Judge.
Thank you, Counsel. Good day to you. The court now calls case number actually, I'm holding off on that matter. Matter set for 10:15. We haven't arrived at that time yet. And back to the suffix 798. That's Metro Med Pain Management versus City of Detroit. And Ms. Galan has ended her appearance previously on behalf of the City of Detroit and updated the court in general regarding this matter. For the plaintiff in this matter, your appearance at this time, please.
Good morning, Your Honor. Joe DeCrube on behalf of the plaintiff.
All right, your P number for the record.
P84445, Your Honor.
All right, thank you, Counselor. Good morning to you, sir. And Ms. Galan did indicate to the court that there were ongoing discussions regarding resolution and indicated that you guys are apart. There's some separation in the numbers regarding this matter. Anything you wanted to chime in on, Counsel, sir?
Your Honor, I think Ms. Galan and I will probably get this resolved. There's a matter of one bill that I don't know why was not. Well, I think I know why it was left off of the original pleading, because it was barred by the 1-year back rule when we filed. However, the EOB from the city that declined was sometime in November of 2020, which would have made it 1 year told under the new revised court rules, or I'm sorry, under the new revised compiled laws for the state of Michigan and the reforms. But it is, in my guesstimate, my new amount. We're only $800 apart, and we could probably bridge that gap a little bit. So I think maybe 30 days would be fruitful if Ms. Gallant wants that. If not, we can fight it out now, but it's up to her.
Yeah, Your Honor, in light of the fact that I just received this bill, I knew we were off. I might have to brief it. Unfortunately, for this low amount of money, in terms of it's not that much, but the principle, in all fairness to the city, I'm not going to just agree to a bill which is barred by the 1 year back. It's debatable, And so 30 days, within 30 days, I will have either a motion entered if the court will allow, or leave, or will to settle.
All right. Well, I'll go ahead and grant the 30-day adjournment. I understand that there's matters of principle here. And that one-year back rule and reforms are significant considerations during the time that we're in now. So I'll go ahead and set it over for 30 days in hopes that you might be able to resolve it. And you know, in theology, the number 8 is the number of new beginnings.
Okay, I'll take that as a start.
Perhaps a fresh start. I sense, of course, this has been some discussion to get to whatever number that has been discussed apart from this 800. So it's kind of hard to talk about because you already negotiated, I suppose, to get to where you are at this point. So with two smart, experienced lawyers, I'm sure that that 800 won't destroy the entire thing. We'll see 30 days from now. I will grant leave to file a motion if that becomes something that you think necessary. And the reason the court will grant that leave is because the parties, I believe, have been negotiating in good faith as a result, as it relates to the attempt to settle the case. And so if you wish to file a motion on either side, you can certainly do so. And the court will hear the motion. Right.
Thank you, Your Honor.
Thank you, Your Honor.
We're going to bring this back on April. I'm going to bring it back on April 18th, 4/18, 2022, and that's going to be at 9:45 a.m. 4/18/2022 at 9:45 a.m.
Yes,
Thank you, Your Honor. We appreciate your patience.
Thank you. Thank you. Good day to the two of you.
thank you, Your Honor. You too.
Thank you.
I see Mr. Alley there. Do I have someone from LBNB funding? One from LBNB funding, council on the Zoom. All right, the matter is set for 10:15. I'll call it. I'll call the matter at that time. I see that I have Mr. Hughes on the 10:15 matter. Do I also have Alexander Nichols?
Yes, sir.
All right,
Yes,
this
sir.
is case number 21-240874. This is Alexandra Nichols versus Paul Hughes. The matter is before the court, set for a status conference, scheduling conference. Looks like there is an answer filed to a complaint that's been raised regarding this matter. Your name for the record, the plaintiff in this matter, Alexandra Nichols. State your name, please.
Alexandra Nichols.
All right, thank you, Ms. Nichols. I know that you filed a complaint in small claims court, and subsequent to that time, the complaint was removed to the general civil division. And your claim is regarding a claim for $5,000 that you believe is due to you from the defendant in this matter. Is that correct, ma'am?
It is correct, and I think I amended it to 5,500, but I started at 3,500 and did amendments up to 55.
All right. I'm looking at the file, and I don't see where you found any amendment with the court. Are you saying that you changed the number before filing it with the court? Is that what you're saying?
I
or subsequent.
I have the document here in front of me. I could show you, but because I had to recalculate some things, I did several amendments, and if the last one you have is 5,000, that's fine. But I did amend it at 5,500. And Judge, I tried to get legal representation.
I don't want to hear about that part now.
Oh, I'm sorry.
Thank you. For the defendant, your appearance, your presence, if you will, at this time, please.
Yes, Your Honor. Good morning. Paul Hughes appearing actually on behalf of myself, improper, although I am an attorney. I'm representing myself in this matter. I indicate to the court that the Register of Action shows that I did file my answer to the complaint after the matter had been removed to this court. And I also filed affirmative defenses as well as a counterclaim for $17,500. At that time, a proof of service was also timely filed on the very same day. And that should be my answer. Affirmative defenses, counterclaim should all be before the court. The defendant, the plaintiff, counterplaintiff failed to file any answer to that matter. She is in default. I have filed a default in early February. The Register of Action shows that the court has not entered that default at this time. I'm not sure why. I know the court's very busy, but she is clearly in default. I would ask the court to enter that default. However, I may, if the court will bear with us, I know you have a busy docket. I believe that this matter can be resolved without even prolonging the litigation. And here would be my suggestion. This matter stems out originally from a landlord-tenant action. I have filed a termination of tenancy action, although Ms. Nichols, I'm sure, will agree with me that she has not lived in my home since mid-October of last year. This was a shared residence. She rented out 2 rooms for me. She's not been here, but in order to properly comply with landlord-tenant proceedings, even though she only has a closet full of clothes and a microwave and one other utility in the home, we do have the matter set in front of landlord-tenant court this Friday before the Honorable Alicia Jones Coleman, set for 3 o'clock. The termination tenancy action only. I believe that there is no answer filed. There will be judgment entered. Now, if there is a judgment at this time, I would certainly be open to filing a motion stipulation and no.
Mr. Hughes, I muted you. Mr. Hughes, I muted you because your sound started breaking up for some reason, and I don't know what it was. I could not understand what you said after you told me that there's a hearing in front of Judge Alicia Jones Coleman. So I muted you so that we could kind of reset to hear what you were saying, because something was breaking up after that point. So go ahead and unmute yourself. Okay, go ahead.
Okay, now you should hear me, correct?
Yes.
Okay, I'm sorry about that. I think the problem may have been on my end. What I was indicating to you is correct. This Friday, we do have a motion for termination of or a complaint for termination of tenancy. I anticipate it will be granted because 1, there has been no answer, and number 2, in my opinion only, there is no defense. Now, should order of eviction be entered at that time, and again, she has no physical presence on my property, only personal possessions, then I would be open at that time. I would propose to the court that this matter could be quickly resolved by a stipulation on both the complaint and counter complaint with prejudice. Now, if that is not acceptable, so 1, we would have to see what happens this Friday. If that would not be acceptable to Ms. Nichols, then we can prolong this litigation as long as it takes ad nauseum, I believe it would be a waste of the court's time. And the jury demand has been filed in this matter. I will be asking to amend my complaint. Additional damages have been accrued since I filed my original counter complaint. There is a jury demand on this case. So that will depend totally on actually Ms. Nichols' desire to whether she wants to proceed in this matter or not. There will be, so I'm just suggesting that that may be a way to resolve this matter. There are two options.
All right,
One-
thank you, sir.
Thank you.
Thank you. Well, the most crucial thing here is that I do have the motion for entry of default judgment, and the only reason that has not been signed here before is because it was not placed in front of me. I think because there was a court date pending on this matter, that the matter was not presented in front of me by mistake. And that's an important consideration, Ms. Nichols. You filed a complaint, of course, in this matter. The defendant responded to your complaint and filed a counterclaim. And by law, you're required to respond to the counter complaint that was filed against you, and you did not respond in the time permitted by law. So tell me why you didn't respond to that now.
So I was receiving legal advice from, Your Honor, I've never been through anything like this, so I'm sorry if I'm not following any particular protocol or things to say. But I was prepared to come on and let you know that I needed a continuance because I wasn't able to secure an attorney. I asked for Legal Shield to provide me 3 options. They sent me a guy who wanted me to immediately file bankruptcy when this is a landlord-tenant matter. So I asked them to refer me back to someone else, and they haven't done so as of yet. And so and then the reason why I did file a response, my response is a 6-page response that I had stamped. You said it wasn't done in a timely manner. The advice that I was receiving from Legal Shield at that time was to not respond to anything from Mr. Hughes, only to respond to things that I received in the mail from 36 District Court. And at the time that I received something in the mail from Mr. Hughes, maybe it was past the date, and I called the Powers Chapman, which was the attorney they referred me to, when it was a small claims matter, and they were advising me through that. And initially, when Mr. Hughes began his eviction proceeding, Judge, it was before my lease was up, and that's the reason why I filed a small claims matter. We demolished his garage with the intent to put our 5th wheel trailer in the back. Mr. Hughes reneged on that deal. When he did so, I went on ahead and filed a small claim. We did a custom demolition on his garage. It was built to the
Okay.
top.
Sorry, I don't mean to interrupt. Pleading so speak.
Excuse me, Mr. Hughes. Excuse me.
Let me stop you, Mr. Hughes. Not only do you not mean to interrupt, I won't let you interrupt at this time. So thank you. I'll come back to you in a moment, sir. Ms. Nichols, the challenge that you have here is that regardless of what someone told you, a lawyer that might have been attempting to represent you, whenever you come to court, you're required to have an understanding of what the rules and regulations are. You don't get a pass because you don't have a lawyer. When you file something as a improper, you are treated just like a lawyer because you filed that improper. And I have to, by law, I have to go by the rules, whether a person is represented by an attorney or not. And what happens is that just as your complaint that you filed, if the defendant did not respond to your complaint, you would be entitled to the court entering a default because he didn't respond in the time required by law. What has happened here, I need you to hear me, and then I'll listen to you, but you need to hear what I'm saying because
Sure.
that's determined. By law, when the defendant filed his complaint and counterclaim, the counterclaim is what's really important. He filed a counterclaim alleging damages against you in excess of $10,000. And you did not respond in writing to that complaint within the time required by law. That is a very serious, that's a very serious miscalculation, whether somebody told you to do that or not. That's a serious miscalculation because the complaint was filed in December. We're in March now. You had 21 days to respond to that, and we're 90 days out now. And by law, you are in default. That means that you really, by law, you wouldn't have anything to say about that claim, and the defendant could proceed to entry of judgment. So that's a very, very significant mistake. I understand that you both have something in front of Judge Coleman unrelated to me, and there's a Judge Coleman female who is here, and she's on the landlord tenant division. So you probably need to see if you can get stuff resolved in front of her. What the plaintiff in this matter, the counter plaintiff, that is Mr. Hughes in this matter, he has kind of a procedural advantage now. He's offered to the court, in light of the default, he's asked the court to enter a judgment in this case. And he's asked the court to enter a judgment for about $12,000 based upon the default. I believe that's what I saw. Well, I don't see the exact amount. Anyway, he's asked the court to enter a default on a counterclaim that he filed with the court, and the amount that he alleged in the counterclaim is $17,241. On the other hand, the plaintiff, the counter plaintiff in this matter has indicated that he's willing to walk away. If you're willing to walk away and both sides move on about their lives in this case. That's where Mr. Hughes is. Ms. Nichols?
In light of the fact that when I was receiving some legal advice from legal aid, the lawyer told me, in fact, that Mr. Hughes was in default of when he did not attend the second hearing that was scheduled with Ms. Coleman, of which I hired a process server to serve him with, of which he missed on his own. Now, I understand what you said, that me not knowing certain rules does not grant any type of or carry much weight in this matter, but
Let me stop.
that's the advice that I received. And
Yeah,
I'm sorry.
Let me stop you. Thank you. With that advice that you received, that has to do obviously with the case in front of Judge Alicia Coleman. But with that advice, first of all, lawyers should not be telling you things like that if they're not going to represent you and so on and so forth. But speaking to me regarding what some lawyer said, that doesn't mean anything if that lawyer is not here. That's the dumbest thing that.
Well, he could.
Excuse me.
Sorry, sir. Sorry.
I'm gonna sound like I'm being rude now, but I'm not being rude at all. And this is not directed to you. But I don't care what a lawyer said that's not here. And whatever a lawyer says, even if he's here, doesn't amount to a hill of beans to me if it's not consistent with what the court rules are. I don't care what Mr. Hughes says if it's not consistent with the court rules. It doesn't matter to me. I respect the fact that they're lawyers. I'm a lawyer too. But the rules are what the rules are. I don't care about all that other stuff. Now, the lawyer told you that in the other case that Mr. Hughes is a default. I don't know. That case is not in front of me. If he may very well be a default. I won't rule upon that case. But the thing that troubles me is that if a lawyer tells you that Mr. Hughes is a default in the other case because he didn't respond, and then tells you don't respond to anything that Mr. Hughes tells you, only respond to what the court tells you. How can they, on the one hand, tell you don't respond to what Mr. Hughes files, and on the other hand tells you that by him not responding to what you filed, that he's in default? That right there, it makes absolutely no sense. The problem in this case is that you didn't respond to the written document, and by not responding to that, it places you in default under the court rules. Now, I don't know what Judge Alicia Coleman is going to say regarding the landlord tenant case that's in front of her. I have no idea what that is all about. It seems to be that Mr. Hughes, well, one of the things he was saying is that that case might, this case, I don't know. The problem with this case is that you're in default on this case. And that means that Mr. Hughes could take a judgment against you. For announced claim, and it also means that you would have the right to file motions to set that fall aside, explain under oath why you didn't respond timely to the complaint, so on and so forth. But the case is that this. So why don't I do this? Well, Mr. Hughes, you had something else you wanted to say.
Your Honor, just,
So
just-
please mute yourself so you don't interfere with this court's hearing. Go ahead, Mr. Hughes.
thank you, Your Honor. Just two things. I believe, my understanding was that Ms. Nichols was saying, first of all, she never filed a landlord-tenant case against me. I filed the termination of tenancy complaint that will be heard this Friday. I believe, if I understood her correctly, she was indicating that she had tried to get legal advice on this case. And she's had 3 months to have an attorney file any kind of pleading on her behalf. That's why she's, so the issue of whether or not she had proper legal advice, got an attorney to represent her or anything else, as the court indicated, really has no validity at all. She has had 90 days to get an attorney. Now, again, I just want to emphasize that this matter can be resolved. It can be put to bed completely after we get a resolution of this case Friday before Judge Alicia Jones Coleman. I highly anticipate a judgment of eviction will be entered against Ms. Nichols. If it is, then I would highly suggest that this matter be set over for 2 weeks, at which time this matter may be, could be mutually dismissed with prejudice. That will be totally up to Ms. Nichols. I'm prepared to litigate this case forever if we need to. I don't want to. That's not my desire. I want to put this matter to rest. I think that it could be put to matter to rest after Friday with a conditional dismissal entered in landlord-tenant court. I'd be more than happy to dismiss this case depending on what happens on Friday. So a short adjournment, a week or two, I don't think there's, then we'll know, are we going to go forward or are we not going to go forward? That's how I see it. I thank you for discussing this matter with both of us and taking the time to do so.
All right, thank you, Mr. Hughes. I've heard you say several times that you're ready to litigate this and this will be drawn out and what have you. Well, you've probably practiced in front of me before, you know, and you'll litigate, but nothing's going to be drawn out here. But I do understand the desire, the impetus to try and bring this to some resolution. Ms. Nichols, I am going to go ahead and take under advisement the application for entry of default in this case, and I'm going to send it over 2 weeks out to give some to get some sight as to what happens on this Friday. It does sound to me like the most reasonable course of action by the parties mutually is to mutually dismiss their claims in front of me and in this case, because this doesn't, for lack of a better way of putting it, it doesn't look like something that's going to work out in any meaningful, advantageous way because of the disadvantage of the default that's potentially entered in this case. That is problematic, and overcoming that hurdle is a significant hurdle. And so it probably makes sense for the parties to find a way to move on from this. And it would be a dismissal with prejudice. Nobody gets any claim against anyone. But I'll wait until after the hearing on Friday in front of Judge Coleman, and I'll take a look at this case. I'll bring it right back. So I'm going to set it over the 28th. I got a lot of stuff on that date, but I'm gonna go ahead and squeeze it in and get you back here as quick as I can. 3/28, 22, I'm gonna go ahead and set it at 10 o'clock a.m. I'll review the matter at that time. In the meantime, I wish the two of you well, and I will see you again on the 28th of March at 10 o'clock a.m. Good
Thank
day
you,
to the two.
Judge. Thank you.
Thank you.
I previously checked regarding this case, but I'm going to call it now. This is 21-170-938. This is LBNB Funding LLC versus James Alley. The matter is before the court, set on for a first hearing after the submission of the defendant's answer in this matter. Your appearance for the plaintiff in this case.
James Alley.
All right, thank you. You're not the plaintiff, you're the defendant, is that correct, sir?
Yes.
All right, go ahead.
Navjot Francis on behalf of plaintiff's attorney of record, Your Honor.
All right, thank you, Ms. Francis. Your P number for the record, if you will.
Sorry, P72322.
All right, thank you, Madam Counsel. It looks like. Okay, got it. All right, so it looks like this complaint alleges damages in the
Judge,
amount of $696.54. And looks like this is an allegation regarding a former Credit One bank account or credit card. Madam Counsel, you were going to say something?
Sorry, Judge. Could I speak to the defendant in a breakout room?
Yeah, I think that will be a good thing. Mr. Alley, I'm going to give you a notification to go to the breakout room and speak with Ms. Francis, who represents the plaintiff in this matter, and then you'll be able to click back in as well. So you get a notification for me to go to breakout room number 1, and I'm sending that notice to you right now, Mr. Alley. So
Thank you, Your Honor.
all right, thank you, sir. All right, who's the gentleman that's there?
You know, last 3 case 511. It's the real. With Mr. Rusin.
We already dealt with that case. Right?
Yes, we did. I don't think he heard.
Was he already on?
He was on.
Are you Daryl Williams? Take your phone is on mute, your device is on mute, so it's.
Yes, I'm Daryl Williams, sir.
All right, so I already heard your case, sir. There was a motion to set aside an installment payment plan that you had, that you were paying $300 a month, but you were behind by about $7,000. Why didn't you respond when I called the case?
Because I was in the laundromat, Your Honor, trying to wash my uniform for work. Because I have to be at work in about 2 hours.
All right, so you have to, I mean, there's nothing I can do if you don't respond to when the case is called. So what did you have to say about that case? The plaintiff wanted the payment agreement set aside, and I set it aside because it seems like you have not made payments in quite a while. Go ahead and talk to me.
All right, because actually, Your Honor, I never had possession of that car from the time that car left that lot. That car was in my name and my ex-fiance's name. So once we had got that car, you know what I'm saying, everything went, she started tripping, doing all type of other stuff because I had my own car. So she left off with the car, you know what I'm saying? So she was making all the payments on the car. She was talking to credit acceptance, all that. Only time I started getting notices from them or talking to them is when credit acceptance started sending me garnish payments. So I was telling her everything. That's like I still don't have no paperwork for the car. When I told her, can I get some paperwork on the car because you have everything in your possession? Still haven't heard from her. I told her, come to court with me. Still haven't heard with her. Told her, let's make these payments so we can just get this out the way. Still haven't heard from her. So I'm pretty much stuck and getting garnished for pretty much a car that I never had possession of.
Yeah, I mean, you know, but you signed for it, right?
Yes, sir.
You must have really liked her a whole lot or something.
And we was about to get married.
Oh, my
Yeah, I
man.
proposed to her, gave her the ring, all that, man. Yes, sir, man. It was a smack in the face, man. But like I told her, you know, she was like, "Well, I'm gonna come to court with you. I'm gonna do this." It's a smack in the face. But like I was telling them, if they look at the records when she made those payments, the receipt from her was in her name. It never was in my name.
Well, you know, they're not, I wish I could tell you something that's worth hearing. There ain't a whole lot you can do about any of that. Man, you co-sign or whatever on that debt, man, that's got you locked in.
I understand that. I understand that, Your Honor, and that's cool. But my thing is, why can't she get garnished as the same as I'm being garnished? Because if I'm losing, she need to be losing too. I'm just being real. Because I never had the car.
I agree with you, actually. I mean, it's, and you know, I know you're kind of bitter about it, but you're actually not, you're actually right in terms of, they should be going after her as well. I can't give you an answer as to why they wouldn't be doing that. Maybe with this, the payment order set aside, that's when they're gonna go after her. If you're being garnished, one of the things that you can do is you can file a petition with the court. You have to put it in writing on the second floor. You can file a petition with the court asking the court to put you on some type of payment plan that's more reasonable that you can pay. And what you have to do is when you file that petition, just make sure you put in there that the other person was supposed to be paying and they were not paying, and that's why it got behind, and that you can't afford to pay $300 a month, and that you're asking the court to allow you to pay X amount. That's what you want to do.
Okay.
By filing a petition for installment payments. That's probably your best relief to try to deal with this a little bit.
Okay.
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 I do wish you well. I wish you had a little better circumstances. I wish it would have worked out with the two of you. Have any children together or no?
I'm 44, but I'm 43. I'll be 44 in July. No children, man. I just work at Ford. I'm a fire marshal at Ford, and I take care of my god kids because they need a leader in their life. So that's what I'm doing, brother.
All right. All right. Well, I wish you well. Get on top of that situation and see if you can get some relief from the garnishment is what I'm talking about. Okay.
Okay. I appreciate it, Your Honor.
All right. Wish you well, sir. Bye-bye.
Thank you.
Okay, we're back on the record regarding the suffix 938 LVMB funding versus James Alley. The parties did take a brief retreat to speak and talk about the matter in a breakout room. Ms. Francis, if you will, update me on things this time.
Yes, Your Honor. We did agree to a consent judgment for the full balance, and defendant will make payments of $50 a month beginning April 1st and by the 1st of each month thereafter. And he was going to give me permission to sign his name on the consent judgment on the record, if that is okay with Your Honor.
All right, Mr. Alley, you went into the breakout room and you discussed this matter, and you're in agreement to that a judgment could enter for the balance that is due on this account, and that you would begin paying it on April the 1st at $50 per month. And as long as you made those payments, that would resolve the underlying case in this matter. Is that a correct statement of what the agreement is in this matter, sir?
Yes, Your Honor, it is.
And you have no problem with if Ms. Francis submits a document to me with that language that I go ahead and sign, that she'll put your initials on it, I go ahead and sign it, as long as it says what you agreed to, correct, sir?
Yes, Your Honor, that's fine. It's all on record, so it's all good.
Yes, sir. And you know that if for some reason that judgment says something, that it shouldn't say that all you need to do is come back in on the Zoom and I'll speak to you and you tell me what's wrong with it and we'll set up here and make sure it gets straightened out. You understand?
Yes, Your Honor.
Whereas there's no trick here. If a mistake is made and you get it,
Yeah.
you say this, you're not stuck. You just come back
Yeah.
and say, Judge, reached an agreement, but it looks like something went wrong in the paperwork and then we'll figure out what went wrong. We'll take care
Yes,
of it.
everybody's human. You just got to watch out for it.
Watch for humanity, that's for sure. All right, Ms. Francis, you can go ahead and submit the order. I'll make sure it says what it should say and I'll sign off on it again. We have a backstop and if something goes crazy though, I'll see Mr. Alley back in the Zoom and he'll let me know and we'll figure it out.
Thank you, Your
All right.
Honor.
All right, take care. Thank you to both of you. Have a good day.
Thank you, Your Honor. You
Bye.
too.
Good morning, everybody.
Good morning. How are you?
How are you?